Good morning, good afternoon to all of you. I'm Indranath. I'm a faculty in the law school, and it's a really pleasure, a delightful afternoon, please, if you're joining from India. And thank you to the organizers for making me the moderator. And I've been joined by my distinguished colleagues, Professor Krishna Singh, who is an associate professor in the Jindal Law School, Professor Dev Gangjee, nice meeting you, Dev, after a while, Professor Intellectual Property Law, Faculty of Law, University Oxford, Professor Althaf, an assistant professor in Nanyang Business School, nice meeting you, Althaf. My very old colleague, Professor Padmanabha Ramanujam, hello, and Professor Shohini Sengupta, Professor Shohini Gupta, assistant professor, and I beg your pardon, and Professor Ramanujam is the dean of the IFIM Law School in India. I hope Professor Ramanujam has joined. So without much ado, we have great speakers this afternoon, and we don't have that much of time, So I'll quickly start, and then, would request my colleagues to set the ball rolling by through the opening remarks. So the title of the session is, it's let me get it right: Disruptive Rights for Disruptive Technologies, the Increasing Relevance of Intellectual Property and Other Commercial Rights. I mean, the moment I hear the term disruptive technology, it takes me back to the discussion that I had with a number of my colleagues, that how in India at least, that how the mobile technology has really helped in a number of ways, many ways. And we really saw the benefits of such technology during this pandemic, when many of students, faculty members, and others who actually use the technology sort of to connect to different things and helped them in many ways during the pandemic. So so there was a shift from, say, not all would have laptop or computers, but we ensure that we have mobile phones, and that to smartphones with technology like 5G, 4G, which sort of a positive disruption happened. Of course, with such technology, with such mobile phone industry, sometimes we think of questions like, okay, what are the IP rights associated? What are there any issues related to access? Then we could have questions like, what are the privacy issues? And it's been discussed all around the world. In India, we hopefully will have a law in that regard fairly soon. So these are the questions that would come to mind. And and there are a number of questions that I would be sort of requesting my colleagues to respond to. But so with this in the background, and as a context, let me first start with my colleague, Professor Shohini. And Shohini, for your opening remarks, I would please request you to keep it to a couple of minutes, 2 to 3 minutes. That'd be great. Thanks very much.
Thanks, Indranath. So good afternoon, everyone. So before I start talking about intellectual property and other sort of commercial rights, I think it's important at least for me to get into this by framing the question a little bit. So when we look at digital technologies, and I'm going to talk about disruption in a second, but when we look at digital technologies, and I particularly look at the intersection of technology, finance, and law, we are tending to look at technological innovations that are constantly creating new forms of knowledge and helping cultures evolve. And now there are digital traces marking every human interaction in the digital space. Now, coupled with this, as the opening remarks suggest, there are now over 1 billion people that have become new internet users, and therefore digital connectivity has been amped up in the last couple of years. Now, what this really looks to me is that cultural systems no longer, even if they have been in the past, are no longer a discrete but a continuum. And that these cultural boundaries are therefore fluid and constantly shifting. So much of our predominant legal discourse, whether it's intellectual property or evolving conceptions of privacy and data economy, do reflect assumptions about cultural systems that are no longer accepted in discipline disciplines such as anthropology, music, folklore, and so on and so forth. So these cultural evolutions that have emerged as a result of creolization are creating or re-emerging or adding to or defying sometimes these very strict boundaries or these really strict legal concepts. Now, for me, disruptive technologies spark two things. One is disruption, of course, in the way that technology itself has changed. So, for example, if we go back to the 18th century, the telegraph being used, say, for not just communication purposes, but also military and political reasons. And that's always existed. But I think the second marked difference, which is coming out now, is the disruption to socio-cultural and socio-legal aspects. So therefore, a fundamental debate at the heart of cultural evolution and IP frameworks, for instance, has been regarded to be the contours and objectives of this new cultural revolution and its products. So therefore, there is a tension between, culture being regarded as a public good, and the new OTT rules in India suggest something similar, where the state has an incentive to come in and regulate a so-called public good vis-a-vis other conceptions of the same cultural goods, which are being regarded as private property, for example, under IP laws. So the traditional sort of conflict between ownership of physical books versus ownership of e-books and so on and so forth. So therefore, I'll keep my comments limited, but I think for me, what's really interesting about this disruptive technologies, and the aspects of digital rights flows both out of technological developments driven by changing consumer patterns of consumption, but also these newer aspects that are building upon our cultural evolution, which is customization, evolution of legal frameworks that see a tension with other forms of legal frameworks. So I'll keep my comments limited now, but I would love to come back and revisit some of these later on.
Thank you very much, Shohini. You raised, extremely interesting points. Of course, we need to discuss these further. May I now request Professor Padmanabha Ramanujam for his opening remarks?
Thanks, Indra. And I'm so sorry, I was the technology disruption was making it impossible for me to actually log in. So I think we're all on the same interesting topic today. But welcome to all the co-speakers, and thank you so much, Indra, for having me here today. This topic is very close to my heart, and in fact, it's been a research topic for me for quite some time. So I would want to talk about two disruptions and talk about more from a non-economics standpoint, more from a transaction cost standpoint, more from a standpoint that how these disruptions are evolving and how intellectual property rights could be an hindrance, for some of the disruptions actually taking place. I would want to be on the other side and want to face a lot of music from the other speakers, but I really wanted to make one or two important points. We all were going through Corona, and we went through a boys' locker room episode. And in boys' locker room episode, we learned that, how disruptive the technology could be and what are the dark side of that disruption could be. And I knew that boys' locker room was not just a unique problem for India. So when I started digging more deeper into boys' locker room, I dwell into a very interesting proposition that was actually taking place in Netherlands by two interesting bots called Sweetie 1.0 and Sweetie 2.0. And I think that disruption, that technology and the disruption that actually was happening, I think is a very interesting thing for all of us to know, how intellectual property rights could actually become an hindrance for something that is nuanced, that is taking place. How do we draw the lines of morality? How do we, does intellectual property rights does dwell into the realm of morality? It was very interesting for me. So let me articulate. So when I dig deeper into boys' locker room, went to Netherlands, there is a beautiful NGO called Terre des Normes, which is basically fighting for the child rights. They created Sweetie 1.0 way back in 2016, and this was the Sweetie 1.0 was a bot, so it was given a face of a 11-year-old Filipino girl, and this bot was made, was asked to go and visit different chat rooms, and in the span of 1 year, they could record that 1,600 people were there as child abusers who were asking sexual favors from this bot. And it was very interesting for me to know that how this innovation called Sweetie 1.0 could actually help in resolving some of the issues that many of the technology as a disruption is actually throwing to us. But unfortunately, many countries did not press any crime case or cases against these offenders because such an offense could not have been committed in the first place against a bot. So there is disruption on one side, there is intellectual property, but there is also a larger morality question on the other side. Why such disruptions could not, take an effect, in law, and and why it did not, move forward. But in 2020, if you see, Teredes Normus did not stop there. It went into a Sweetie 2.0, which was an artificial intelligence bot, and the number of cases only increased. So when we are talking about disruptions, we also should be mindful that one thing could be the realm of the property rights that are defined as to how these new technology are coming into being. The second one is how other important laws need to change to help these innovations to actually have a real effect in the society is a larger question which goes unanswered. Added to that is also an artificial intelligence driven car. A human being is now supposed to code AI driven driver to make a judgment between a young child or an old woman. Now, where is morality there? How can property rights protect such a morality or a decision making there? I think it is a complex set of rules, a set of rights. How do you define property rights in that complexity? I think it's going to be very interesting, and I think we will dwell into some points as we move forward in today's talk. Thank you, Indra.
Thank you so very much, Paddy, if I may. Intellectual property as a disruption. That's a very good point that you have raised, coming from a law and economics professor. But we'll discuss this further. Thank you so very much. If I may now request Althaf for his opening remarks. Thank you, Althaf.
Sure. Thank you very much, Indranath. And I'd like to thank the JAGU for organizing this as well. So I think talking about disruptive technologies is very pertinent today because we are in the midst of a crisis. And I think, as the previous speakers alluded to, disruption has in many ways has also sort of helped us in certain sense as well. So I think that I would like to first dismiss the perception that disruptive technologies have a negative implication to it. I think we must sort of move out of that kind of perception. And instead, we must embrace disruptive technologies. Yes, it is true that these technologies are disruptive because they sort of alter completely or turn things on their heads when it comes to existing practices and norms, business models, for instance, regulatory approaches, and even the application of existing laws to these new technologies. So those are the challenges that these technologies pose, but we must be ready to embrace these technologies because of the fact that they are actually increasing our efficiency as human beings. They are protecting our well-beings if we develop these technologies correctly. So there are many things to gain from these technologies, right? So I just want to start with that. To give you an example about the Singaporean perspective. So as you know, we all hit the pandemic at the same time. But in Singapore, many consumers were not really accustomed to using online platforms before the pandemic as much as they were after the pandemic struck. And in many ways, e-commerce was set to disrupt the retail economy and retail sector. But given the pandemic and given the changes in consumer behavior and so on, we can see that even the retail sector very quickly adapting to these new disruptive technologies and embracing them. So I think the key is to adopt these new technologies, to base your innovations surrounding these new technologies, and also to adapt and improve the skill set that we have in order to face these new technologies and utilize them for the benefit of all of us. So I'll just start off with those remarks.
Thank you, Thank you, Althaf. Thank you very much for your opening remarks. That sort of, takes us back to the question, should we be using disruption as a word, when it comes to a positive technological shift? But we'll discuss on this, aspect as well. That takes me to Dave. Dave, if you would like to share your opening thoughts with us. Thank you.
Yeah, thank you, Indra. And I'm really going to just agree with all the three previous speakers. I fully endorse what Shohini said about technology being a socio-cultural phenomenon, and we've got to sort of keep that in mind. It's not just something designed by computer scientists, but it comes from society and it's embedded within society when it's applied. And if you look at all the concerns about AI drawing on data and the data containing biases for job interviews and things like that, you can't escape from the fact that sort of social and cultural norms intersect with sort of technology. So I strongly agree with that. I strongly agree with what Paddy said about not being too gung-ho about IP law in particular, because laws tend to lag behind. And that was a point Paddy made quite powerfully. And then IP is one of those laws which lags behind and acts as a block or an impediment. So if you think about the pandemic again, school children and their teachers were reading out their favorite books to each other because they couldn't meet in person. And reading out an entire book and placing this online was perhaps performing a work or reproducing a work or communicating it to the public. And these are all forms of copyright infringement. And then you'd have to run an educational use sort of exception against it, which hadn't been tested or tried before. So the YouTube sort of algorithms, content ID algorithms were pinging these things as infringements. And then there was a non-enforcement because it would look terrible to sue school children, but technically these were infringing rights. And that's part of the lag kind of problem there. And I agree with Althaf. Disruption isn't bad. Markets sort of online retail, the shift. The qualification is towards the end, Althaf said, but provided these are for the benefit of everyone. And what the technologies we've been talking about so far tend to be platforms and therefore disruption at scale. And you can see questions arising around competition law, where large market platforms tend to consolidate, or privacy concerns, where the data is then harvested or reused. So the disruption is great, but a new set of problems then needs to be managed. It's not all good. I want to say two things in addition. One is I want to accuse us all of using the wrong term, myself included, because the Harvard professors who came up with disruptive technology in the beginning had a very narrow and specific use in mind. And they thought of technology that starts at the margins and then works its way towards the center slowly. And it's allowed to slip below the radar and disrupt the market incumbents because it comes in from the peripheral field of vision. And what do they mean? They mean someone like Netflix in the old days, when Netflix was a mail order business. And Blockbuster was the big incumbent. And Blockbuster was great because you went to the store, you saw what you wanted, you rented it immediately, and you watched your movie, the latest movie, happily at home. Whereas in Netflix, you had to order it, it would be posted, it may or may not reach. And there was about a week to a 10-day lag before you got it. But Netflix built up customers around the periphery of Blockbuster's market. People Blockbuster really didn't service. And once you switch to the internet, Netflix started eating into Blockbuster's main market and completely overtook it. And now we have Netflix in Blockbuster's history. So that would be an example of starting from the margins and moving in. But my sense is we're using disruptive technology as anything which disrupts market incumbents or a way of doing things. And that's a broader sort of definition. The other point I want to make is innovation is bigger than IP. So if we're thinking of the question of how do we facilitate sort of disruptive technologies, is IP the answer? And as Paddy already said, IP could be a block or an impediment, or it could sort of help in certain ways. Then we've got to remember that there are other ways of helping. For example, tax credits. You give an industry or a sector tax credits. You offer a prize, which is an upfront ex ante sort of target for people to aim for. So you set the parameters of a win very carefully. This is what it means to win successfully. And if you get there, antimicrobial resistance would be something that people are experimenting with in terms of offering a prize to incentivize innovation. And the other alternative is a reward system. Generally make good stuff, then you come to us. And if it's good enough, we'll give you a reward. So we leave it open in terms of what people are making. And at various points in history, in the 18th and 19th century, different national economies, including the UK, experimented with prizes and rewards. We're still experimenting with prizes and tax credits, and there are alternatives to IP. So I'll end with that.
Thank you, Dave. I think it was fascinating, and I think we probably would, by the end of the session, will add a new term, other than just disruption, right? And the history of the term and epistemological questions connected to such to the use. So let me sort of move on to my colleague Krishna. Krishna, your thoughts. Thank you very much.
Thank you very much, Professor Indranath. And first of all, I would like to thank the speakers that spoke earlier, and they have laid down fantastic groundwork for the session to come. So when I look at this topic that we are dealing with today, which is disruptive rights for disruptive technologies, and in the context of intellectual property rights, I am reminded of a term that was coined way back in the last decades of the 20th century called English dilemma. A term which basically posed that when we deal with newer forms of technology and disruptive technology, we are looking at something that's called a double blind, that if we regulate a technology too early in its stages of development, then we basically hinder its growth. But if we wait long enough for the technology to become prevalent and present in the market, we then lose the power to actually be able to do much about it, and it kind of becomes pervasive in the society. And this term and this concept has been used often in the context of regulation of technology in general. But I believe that this that does have an application also to intellectual property protection for such disruptive technologies. I think we are facing a similar dilemma. What kind of protection? To what extent do we grant this protection to disruptive technologies? And now we are also dealing with a whole other question. It's not just a question of protecting, for example, artificial intelligence being a technology. Do we only protect the algorithms? If so, what is the correct instrument? That remains a question. But the other question that has popped is what to do with the products of AI when AI itself is able to create downstream content, and how do we actually protect it? So this is a dilemma that we face, and of course, the resolution of this dilemma is not going to be a one-day affair. It's part of a long-term process of which I believe all of us are part. But I do believe that one thing that I believe is important is that we need to kind of revisit justifications of intellectual property. And if we go down that lane, we see that in terms of both personality based and labor based deontological theories of justifications of intellectual property, as well as incentive based utilitarian theories, have sort of, at least in many ways, lost their relevance, if not completely, of course not completely, but in parts and bits. And therefore we need to rethink what justifications of intellectual property should kind of remain in place in times to go forward. And I would just like to kind of conclude my take by saying that I do believe that the decisions that we make in terms of what we protect and to what extent we protect needs to be teleologically driven, in the sense that it should be the eventual aims of individual empowerment that should kind of inform our decisions, and that should allow us to take better decision terms. So with that, I conclude, and yeah, thank you.
Thanks so very much, Krishna, for raising these most important, these interesting aspects. The opening remarks really, been thought-provoking, at least for myself, I'm sure for the other speakers as well, with the terms like, it's a social cultural phenomenon. I have, when we talk about that, how much machine is involved and how much intervention is required, we have had occasions of, understanding a thinking technology, right? So what kind of interventions would be required from a technical aspect, from a legal or regulatory aspect? The usage of the term, as they've rightly pointed out, that, what is the term, what was the initial meaning associated with it? And society and cultural issues, what are the implications of those? I mean, and then we moved on to the issue of that, how we should now control, right? A control being a general term. But let me take you back now to if I may, to some sort of historical development of all these changes that, started to happen, and the conditions under which they started to happen. You may want to cite some examples or an example, that be of your interest while explaining or answering this question. So essentially, I'm looking at the general question like, how do disruptive technologies evolve? What are the emerging trends? So that's very important. So that we're talking about AI driven, in which sector are we talking about, right? If it is IoT, Internet of Things, what is the sector? What is the application that we're looking about? What's the history behind that? What are the changes? What led to this form of evolving, this form of technology? It's not about it's just happening in a lab and just suddenly been marketed. It doesn't happen that way, right? So maybe you want to use take help of certain examples while explaining and responding to this question. So if I may sort of go to the same order, in the same order. So how do disruptive technologies evolve, and what are the emerging trends? So Shohini, if I may start with you, and would you like to respond to this question? Thank you.
Sure. So as I said, I'm interested very much in the regulatory architecture, and I've been looking for the past year around questions of the OTT regulation. And why, because content regulation in India has been focused around OTT regulation for the past couple of years, in fact. So the primary questions that interest me are, what are the objects of state intervention, which is primarily through law, and what are the specific forms of these kinds of interventions, and what sort of wider political environment does support these kinds of interventions. So the first thing that I see, going back to history, as you said, is, I started my conversation by talking about the telegraph as a mode of communication technology. But we know that because we sort of in India derive even our current formulation of the modern nation state from a colonial form, we know that this creation of the modern nation state itself is rooted in an ideological hegemony, because the state has always been a public administration apparatus, which privileges certain conditions, whether it's capitalist accumulation or establishment of a formal government, as it may be. But if you look at 18th century legal development of the media and content space in India, and I'm referring to radio, and I'm referring to different kinds of media regulation, whether it's a Telegraph Act, but also the licensing regulations, the Vernacular Press Act, but even something more controversial like the Rowlatt Act, and the Post Office Act. A lot of these acts still continue till date. We see a very clear economic and political goal, which is based on centralization of power with the union government. And this is often framed as a benefit for the regulatee, at that time the native population, and so on and so forth now. But the interesting thing is that a lot of these regulatory incentives that we saw in the development of 18th century law, and law being used as a state instrument, are also seen now. So there's a new OTT regulations, or any kind of media regulations that have come about in India in the past couple of years, see a very clear centralization of power, creation of new regulatory functions through delegated legislation, and a lack of consultation and transparency around why we are regulating, for whose benefit we are regulating, and what are the end objectives of regulation. So when we look at disruptive technologies in India, one of the things that we can derive, at least in this political context, is that we are drawing very heavily from the colonial state. And the modern regulatory state is continuing in many ways through legal means, because it is one of the most sort of direct ways of doing so. We are seeing a continuation of those regulatory objectives. Until we understand these incentives for state intervention, I think it's very difficult to form a perspective, at least long term, on this entire innovation and digital ecosystem.
Thanks very much, Shohini. I mean, that sort of takes us to the question of whether have we reached an optimal solution, right? What are the ways we should be behaving, taking into consideration what you have said, so that you maximize the advantages, something that Althaf talked about and others have also said. So maybe I just park this question, and it may come back again, to you. Thank you very much, Shohini. Patty, would you like to sort of respond to this question, the first question that I said? Thank you.
Thanks, Indra. Yes, for me, I think so. The maximum disruptions that would actually take place would be to address the problems of disruptive technology. So technology is going to address the problems created by technology. As I was telling you, Boys Locker Room, actually gave me a lot of in-depth idea. It was a private chat room, an Instagram chat room. It was the outcome of the technology, where people could sit, talk about. But how do you address what is actually transmitting behind, these technological barriers which nobody can be part of? I think technology again become an answer to address these disruptions, right? The Sweetie, a bot could be a proposition to address what is happening on platforms which are not accessible to everybody, right? So I think going forward, there'll be more disruptions in terms of technology trying to address the problems faced by technology, and many of those solutions are coming from open source platform. So that is where I agree with Dave that intellectual property rights may not be the only solution for how do you regulate these disruptions. So there could be other platforms, because if you see, the maximum number of disruptive technologies are not coming from a closed source platform. They're all coming from an open source platform where it is easy for people to understand change, collaborative research, easy to use, easy to adapt, easy to have access to the technology, right? So that is why that disruption is happening so fast. But having said that, my interest in this entire disruption would be to see how technology could be used to solve the problems actually raised by technology itself. Like for example, as I told you, Sweetie 1.0, 2.0 is a great example for us to know how technology becomes an answer for disrupting platforms of technology. Like let me expand. When I got into this idea of Sweetie 1.0, 2.0, I saw only why very few countries took up, and started following, or started filing cases against these offenders, why other countries did not. Because, they thought that such an offense could not have been committed against a bot in the first place. Therefore, how you regulate the space, how you regulate technology, also becomes self-regulatory, in a way that do you have to regulate the space, or do you use technology to regulate technology? I think that space is going to be really interesting for me as far as disruptive technologies, because we are just hitting, I would say, we are just opened up, and I think a lot more is going to come, as far as the problems that are actually being led by these disruptive technologies, and how solutions actually could come from technology. So this use of technology to answer the disruptive technology, I think, is going to be the most interesting space for me. And how do you regulate this space is going to be a larger question for me.
Thank you, Patty. Thank you for these interesting points. That what you said essentially is technology. The real solution is there in the technology, and not really. You don't have to look for anywhere else. That's a very good point. Maybe then I can move to Althaf. Althaf, your thoughts, please. Thank you.
Sure, Indranath. So the question was, how do disruptive technologies evolve, and what are the factors that could influence these technologies, right? I think there are a number of factors that could be relevant, but to me, primarily regulation, I think, is a very important factor. So if we look back at the internet, I think in many ways the internet itself could be regarded as a disruptive technology in the 90s, right? When it started being used, when it was being used by consumers for the first time, and it changed how we communicated and transacted with each other. So in many ways it was disruptive, and I think the regulators had a serious question to ask and decide whether they are going to regulate the internet, and certain policy decisions were made. So for instance, the US Congress enacted several laws that were related to the internet, such as the Communications Decency Act, the Digital Millennium Copyright Act, and so on. And each of these sort of legislation, they adopted a different approach to regulating the internet and its platforms, and in many ways have been influential in the flourishing of the internet, and to such an extent that some scholars have regarded these interventions as internet exceptionalism. and some have called it and hailed it as the savior of free speech and so on, So in that sense, I feel that the approach that the regulators would adopt to regulating a particular technology could either kill it or allow it to flourish. So I think that is a key factor that could influence how technologies would evolve. And I think the right thing to do is to find that balance. So as I said, these disruptive technologies are for the benefit of humanity and human well-being. So within that frame of mind, I think we need to decide how much of regulation is required so that we regulate the technology in such a way that it evolves sufficiently for our benefit without actually killing the growth of the technology itself. So I think that's what I want to add to the conversation.
Thank you very much, Althaf. I think growth of the technology is what we're looking at, and also at an optimal level. And the nations are at different levels, of course. We need to see that, possibly how India and Singapore can benefit. We can talk about other jurisdictions as well. Dave, over to you. Thank you.
Yeah, thank you. And sorry about the light on my face. A rare and wonderful thing has happened, which is the sun has come out in November in the UK. So I just want to say, so your question is, where do these technologies come from? Give some examples, how they emerge. But I also want to respond to the previous speakers after that. Examples of technologies would be in fintech, the ATM machine, the credit card, these were disruptive technologies. Robotics, AI and autonomous vehicles, which combines robotics and AI, virtual and augmented reality. So the metaverse, which Facebook is supposed to become, CRISPR for gene editing using enzymes with precision, blockchain, 3D printing. These are all examples. Mass surveillance technology would be another example. So looking at the AI example, sometimes technology emerges, disruptive technology, because you see a market opportunity and then you try and fill it. But in the case of AI, as many of us will know, it's about a paradigm shift in terms of how you teach machines to do things. So the previous paradigm, which was unsuccessful, starting from the 1950s onwards, was expert systems, where you feed software a grammar book, and then you ask it to translate from one language to another in accordance with rules of grammar. And software lacks nuance, and it does a terrible job of it. So the old versions of Google Translate is all I'm asking you to remember. It then shifts. There's a whole paradigm in terms of how the AI works. It's inductive, it's data-driven, and machine learning is one of the most powerful forms of AI, where you learn by example, you detect patterns from amongst the examples, and then you can use that learning to analyze new data that is given to you. So you start working like human beings, like young children work, in terms of navigating the world around them, and that's what gives this new version of AI the flexibility to handle new things. So it's a paradigm shift in a discipline. In computer science and statistics and psychology, these disciplines start talking to each other, and it shifts. So how then do you facilitate? And I think one of the really interesting questions raised by Krishna, when the dilemma of too early, too late, and then Paddy picked up and Althaf picked up as well, is what form should the regulation take? And when do you step in? And does technology provide the answer, was Paddy's point. So give technology the breathing space to provide the answer. Here, I think you can tie that question of when and how to regulate to the institutional actors. If it's legislation, you tend to try and jump in early, and then you set rules in a way that might be difficult. It works sometimes, and Althaf gave the example of safe harbors emerging from the Communications Decency Act and ISP liability being conditioned on. If you receive a notice and you act quickly on it, you're off the hook. So legislation works sometimes. At other times, if you hand over to the courts and through a common law method, they come up with a solution that's more flexible. And the example I'm thinking of is Google Books, where because the Copyright Act didn't say anything about whether Google's scanning and then using snippets of books and you could search the books was infringing or not. It was reproduction, but it was reproduction at a hidden layer. And then they just produced a snippet of the books themselves. The technology had 10 years to settle down. Judges used Google Books. Judges liked Google Books. So then when it came to the courts, they said, no, fair use, it's fine. People can carry on doing it. So the institutional actors you choose have an important bearing on the timing question. Courts can let the technology develop and then jump in. If it's legislation, you have to maybe jump in early, and that's a worry. One final reflection on what Shohini was saying. I share her concerns about the history of regulation and where the state is coming from. So if it's a strong colonial state with censorship, a censorship sort of agenda, then that's a very dangerous place to start from. And that's where it is starting from in terms of the history. Of course, the counter argument is big platforms now are as powerful and influential and dangerous, if you like, as the state. And we know that self-regulation hasn't worked brilliantly. So what is our paradigm going to be if it's not the state and it's not left to the market? What kind of hybrid are we going to be looking at for regulation? And I'll stop there.
Thank you so very much, Dave. I think you raised an important point regarding the incentive structure and the framework, under which this disruptive technologies would flourish. Thank you for that. We'll come to this intellectual property question and other incentive structure frameworks in a minute. Before that, maybe Krishna. Krishna, please go ahead.
Sure. So, in fact, I would like to start by kind of pointing out what Dave just mentioned concerning paradigm shift. I think that really is one of the most sort of important sources of disruption and disruptive technologies. But I would just like to add to that by pointing out a couple of other points that I believe are also important sources of disruptive technologies. I think, and I would then shift to the example of blockchain technologies, which I believe serve as a very good example of both the points that I'm going to raise. The first point is that a number of times these emerging technologies rise from some sort of questioning and revisiting of underlying assumptions that have kind of governed a particular area. Let's talk about how blockchain and Bitcoin did it. What they did is they essentially kind of asked themselves the question, what is the underlying basis of monetary systems? And they could reach a point where they realized that traditionally, while governments have been the center of trust could actually be replicated without government being there. And once they kind of realized this, they were able to use technology to create a parallel system of trust, thereby creating an entire system of parallel monetary system, which we are now witnessing. And we don't know what the trajectory of this particular technology is going to be going forward, whether it will continue to explode as certain people predict, or whether it might, kind of fall victim to regulation and eventually disappear. That's something we will discover, but that's number one. And the other element, I believe, is like kind of a very important trigger for continued innovation is recombination of existing technologies. And once again, I think Bitcoin as well as blockchain, and blockchain serves this particular an example of this point in two different ways. One, not only did it recombine existing technologies, that it combined internet with encryption with monetary system and their elements to come up with this. But we also noticed that once it was on the horizon, it was initially sort of envisioned as a currency system only. But today, blockchain is far more than just that. It has been kind of other elements have been combined into the underlying blockchain technology, and now it's being used for so many other things, smart contracts, so on and so forth. So that's a couple of points that I think are going to be an important characteristics in how technology emerges in the times to come. But I do kind of agree very much with Paddy, if I may, that I think technology and its use to solve the problems that these things will use is these things will continue to raise is going to be an important determinator of the trends to come. So yeah, that's, I think, in my opinion, how the trends are going to be shaped.
Thank you very much, Krishna. I think, that sort of brings us to our second question. I think whether we like it or not, intellectual property would have a role, right? And it also connects with the incentive structure and framework that Dave was referring to. It also connects to let the technology flourish as it would. How would you ensure what kind of market structure? What would be the incentive? Would there is a space for technology to evolve? So my question would be, how do you see intellectual property playing a positive role in ensuring that there is a space and ecosystem for these forms of technologies to evolve? Do you see, of course, there could be negative perceptions as well, but for once, let's talk about the positive aspects of intellectual property. in creating that space so that technologies can develop in an optimal manner. And maybe I can reverse the order if I may. Krishna, if I may start with you first, and then if you would like to respond, and then I move on to Dev and so on and so forth. Krishna, thank you.
Right. So I would just kind of restate what I have understood this question to be. So essentially, we are looking at in what ways intellectual property systems are serving as positive enablers of further innovation. Have I got that correct?
That is absolutely correct. Essentially, we have talked about negative aspects of intellectual. Let's talk for once about the positive aspects.
Certainly. So I think intellectual property systems in the past serve as a good example of a lot of positive that has come out of it. I think whether it's in the West when Diamond versus Chakraborty was decided, and it was kind of at that point of time that was an important and very paradigm changing technology. And the fact that the American Supreme Court went on to kind of allow patents on microorganisms when they were created with recombinant DNA. I think it kind of served to boost biotechnology sector, not only in US, but steadily in several other jurisdictions as well. So that's certainly one way in which it has in the past helped innovation to kind of grow. And I do believe that in the times to come with the present technologies and things such as artificial intelligence, things such as blockchain technology, we are going to see an increasing role of intellectual property, which I think is also the theme for the day. And I do think that they will be able to have optimum effect if we are allowed more sort of tweaks in the system. I know that the legislative tweaks are slow and they don't necessarily come as quickly as we would want them to. But I think at the judicial level, we need to kind of give the judiciary certain discretions in terms of charting out contours of what kind of rights are to be allowed. And this is primarily, I think, the reason why I'm pointing this out is I believe the optimum benefits can be derived if the benefits of intellectual property can flow down from the bigger sort of corporate based innovation centers all the way to the individual innovator. And for that to happen, I think we need to kind of redefine certain principles of intellectual property. If that happens, we'll continue to see the positive effects of IP.
Thank you, Krishna. Dev, you talked about the incentive structure, incentive framework. You talked about that. If there is any market space, right, and need, then probably these technologies would develop, evolve, right? How do you see the positive role of intellectual property in this regard? What kind of incentive structure can we have through the application of intellectual property?
Yeah, so I think I'm going to so I'm tempted to say IP should get out of the way. It's not the question you were hoping for. I mean, in terms of how IP can help, but if IP gets out of the way, and I agree with Krishna in terms of the tweaks rather than radical sort of shifts, and I'm coming from the place of watching the UK wondering whether it should change its copyright and patent legislation to accommodate artificial intelligence inventors and artificial intelligence creators. So software that invents things and software that makes paintings and books and poems and things like that. And the reason why we should be cautious is because that kind of software already has certain layers of protection. You can brand the product and you've got your brands. The software itself is either patentable or copyrightable. You usually have some kind of exclusivity over the training data that is used for the software already. So there are a number of existing IP provisions which encourage and incentivize and give you protection. Then the question is, does everything the software produces become recognized by the IP system, and is all of that yours? Whether you're the maker of the software or the owner of the software, the user of the software, you have to identify an owner. But then that's the sort of follow-on question. And that raises sort of two issues. Do you need to do it to incentivize people to make this kind of software? Or are all of the other existing IP incentives, the brands and the rights in the software and the rights in the data, are they enough? And then the other question is the normative one Krishna raised at the beginning. What does it say about the IP system? Is it designed around human creativity and invention? And therefore we don't recognize a monkey selfie because it's not human creativity? Or is it about just, here's something valuable, let's throw a property right over it and let's sort of wrap it up in property? So the 2 points I guess I'm making are, be careful before you recognize something with property rights, because then that creates initial entitlements and you move money around. You concentrate money in different ways in the system. And we need to think about distribution effects. The second point is, use defenses and exceptions in a way that allows the technology to emerge and settle down before then you step in and regulate. So maybe a more generous approach through defenses in the first stage. And once you know what the market starts looking like, then you can step in with legislation as a follow-up. These would be my 2 points. I'm going to apologize as well. I've got a student knocking on my door and I mentioned to Indra that I'll have to run. I've thoroughly enjoyed this. Thank you very much to my colleagues and to the organizers. And I hope this is a very successful series of days. Thank you very much.
Thank you, Dev. Thank you so very much. Nice connecting with you. Thank you. So if I may now move to Althaf. Althaf, would you sort of, agree with Dev when it comes to, that intellectual property would be out of the way and something, something of that sort? Would you, or rather say, we tweak it and then wait intellectual property to step in? Or would you say, intellectual property is the only incentive structure that probably we can think of?
Well, I think I would agree and disagree both, in the sense that I can already see some friction between the intellectual property system and the development of disruptive technologies and even the use of disruptive technologies, right? So take, for instance, artificial intelligence. We all know that AI systems are becoming increasingly used for various things, be it the private sector or the government sector, to screen people. Today it's being used to monitor the temperature of people who might be suspected of COVID-19 and so on. So we need these devices and technologies to be highly accurate. I think that is a common ground that we can all agree to. But in order to have accurate AI systems, for example, if we regard AI as a disruptive technology, I think that you need to train the system tremendously. And in order to do that, you need to have access to data. And often what we find is that data are, proprietary in the sense that they are protected under copyright, or they are protected as private personal data or something of that sort. So I think that if we are to promote disruptive technologies and its growth, we may need to create sort of specific exceptions in IP law to facilitate the growth of these technologies to the extent that there are conflicts. So to give you an example, I think in the EU, this is already being implemented through one of the directives or regulations, if I'm not wrong. But in Singapore, this was recently introduced. We revamped our Copyright Act, basically, in 2021, introducing a completely new statute. And for the first time, we have recognized a computation and data analysis exception. And I think it goes one step beyond the EU exception of data analysis, because the Singaporean exception actually expressly says that you can use, you can reproduce and make use of copyrighted material for the purposes of training AI systems. So in that sense, I think if there is a conflict between the IP system and a disruptive technology, it needs to be resolved in a certain sense. But I think to address the other question of whether IP necessarily would incentivize the creation of these new technologies, I think, well, if you look at certain areas of technological developments like software and open source software, I think these are classic examples to say that you don't necessarily need copyright or patents to promote innovations in certain areas. And we have seen examples of this in the past as well. I mean, if you take a crisis, for example, a crisis in itself may be an incentive enough for people to get together and create new things that are going to be useful for us. On top of that, you might have government funding which is coming towards designing new technologies and so on. And I guess the moral question there is, when these technologies are ultimately funded by, say, public funding, what is the moral of, what is the justification rather of commercializing it and giving some kind of proprietary right to the output of that project, for example. So I think that these are things that needs to be considered and thought about seriously. Yeah, thank you.
Thank you, Althaf. Thank you very much for sharing these thoughts. Paddy, over to you now. Intellectual property as a disruption, law and economics, and whether you see that. Yeah, please.
Thanks, Indra. I think all the speakers have set the tone in a way that intellectual property rights should go away, or the reasons for that, that it may go away. But I will put it from a law and economics perspective so that, we all understand what these disruptive technologies, what it should do. If it fails that test, then the market would make sure that they don't, intellectual property rights realm may not even regulate technology for that matter. So there is, we go back, we look at justification of intellectual property rights. One of the, very interesting justifications way back, which I had written a piece called Justification Through a Game Theory Perspective using the transaction cost. Intellectual property rights, should reduce transaction cost, should help people to come together, in collaborative research. They tell who is the first mover and what kind of, so it should, in a way, it should reduce transaction cost. But if you see, in disruptive technology, it might actually increase the transaction cost. It might not help people actually coming together, or it might increase the cost of that collaborative research, because there might be a person who's holding up or may not want to give away his technology, which may not help other disruptive technologies to happen around that technology. So that is problem one. Second, normally companies and entrepreneurs, used to, they used to dominate the room using intellectual property rights by creating high entrance barriers. Now the question is, does disruptive technology falls in realm with high entrance barriers, or do we have to keep that entrance barriers low? Does intellectual property right create those entrance barriers, or it does not? When it comes to disruptive technology, becomes another question from law and economics perspective. If you see, I think intellectual property rights would be relevant till they decrease the transaction cost. Intellectual property rights would be relevant if they don't create those entrance barriers as far as the disruptive technologies go, because you have to know that the option also lies in the open source technology, which is growing much faster. So people will just swap, people will just switch. The cost of switching is also not higher when it comes to these kind of technology. The more entrance barriers you keep, people already have a market alternative here that they can go and use technologies which are actually prevalent in open source platform. Keeping this in mind, even though intellectual property rights historically has been significant in regulating technology, but the kind of disruptions are taking place today, it may lose its relevance if it does not realign, or if the exceptions to intellectual property rights are not aggressively used for even protecting these intellectual property rights. That is what I would say.
Excellent, Paddy. I sort of, and now I remember the discussions that we used to have long time back. Great to hear your thoughts. Shohini, please. Thank you.
Thanks, Indra.
Thank you. I think I'll continue with that last stream of thought, and I completely agree, of course. I think the way to think beyond the normative, whether we need IP or not, I think it's here to stay. That's the first practical reality, because that's how they'll say, at least in the content industry, that's how it's framed. And then the market dynamics, sort of, at least at the moment, require IP to be there. Now, having said that, I think the future debates which will revolve around digital culture in India and elsewhere will see an intersection, particularly of privacy and IP. And that's because most technologies these days run on data aggregation and on network effects and data analysis. Now, having said that, I think there are going to be contentions between them. So I think the real question is going to be, how is IP law going to sort of tailor itself or be flexible around these other brands or other fields of law. So for instance, the whole idea about data itself, right? Whether data or privacy or informational privacy, for instance, is going to be seen as simply, in the sphere of property and ownership, or an evolving conception of informational privacy, which sees data as bodies or data as human rights, for instance. These different kinds of conceptions of data itself will also be sort of have to be cognizant of different kinds of IP frameworks. So another kind of contention that has arisen, for example, in other jurisdictions like the US, for example, are these social media legislations that a lot of US states have introduced, which is essentially preventing employers and educational institutions to sort of prohibit them from using the employer's data. Now, that creates a sort of contention between a company's trade secrets and, of course, a particular employee's privacy. Now, these kinds of contentions are going to come up in the future. Another kind of contention that you can see is in the music industry, for instance, or what we call the Taylor Swift paradox, which is if the rules of the game demand that for a certain content creator to be in the prime space, you need ad monetized methods to push that content, say on Instagram Reels or elsewhere. Then how do you make sure that individual content creators get their due, on the one hand through IP frameworks, keeping in touch with market realities, but on the other hand, you only see certain brand names like Taylor Swift or Adele getting a prime share of that IP product. Now, if those are the kinds of contentions, then I think the more interesting question for us to pose is, how will the IP laws develop? And just to end on a not too cynical note, or if it is, it may be a slightly cynical note, but if you look at the collective licensing regimes in India, that I think, and the evolution of what we've seen with, say, for example, IPRS in India, really sets a tone. Do we want to continue in an ecosystem where you have these kind of centralized, IP protection, and that being the only model, or are we opening up, like the debate around data, are we opening up our IP framework data as well, and willing to adapt the IP sort of laws in India in tune with, say, competition laws and data privacy laws? That's where I think the real challenge for India will lie.
Thank you so very much, Shohini. Thank you so very much. When you're talking about data privacy, we can start a new panel again, all over again, we just have about 2 minutes, right, to address maybe one of the odd questions from the audience. And I wouldn't be able to go take rounds and then sort of ask each one of you, but maybe at least I can read out the question and just see who would like to respond. And this is in relation to privacy. How can the legal issues pertinent to IoT, Internet of Things, especially regarding data privacy, be tackled? I know we can have 1 hour at least. We need 1 hour at least to talk about it. But I've been assigned the task of ending the session in the next 2 minutes. So anyone who would like to respond to this question, that'd be great. Okay, then I just quickly go to Althaf and request Althaf to respond. Thank you.
I knew you would pick me, Indranath. Well, I think we have spoken about IoT, quite, okay. Very in every single discussion we've had, IoT has come up. I think the key issue here is that, just to very quickly say this, for data protection, we have the Trinity: consent, transparency, and accountability. But with IoT and the devices that we are seeing, we are losing the ability to sort of meet the expectations of the Trinity that I mentioned, because the technology doesn't allow us to provide the maximum transparency to the consumer to actually consent in ways that is sort of meeting the expectation of privacy and data protection. So I think that going forward, devices that are described as IoT, which are connected to a network, speaking to each other, but which are nonetheless collecting our data and information, for consumers to be guaranteed that their information isn't going to be sort of misused or abused, we need to come up with a coherent framework of standardization and certification. And then we also need to be able to communicate these things to the consumer in a very simple fashion. So I think that we need to ensure that IoT devices or designers of these devices are subject to scrutiny in terms of how they meet the privacy standards. And then they need to be certified, and these certifications should be communicated to the consumer in a simple way. I think that is, in my view, the way forward. I hope that addresses the question.
Thank you so very much, Althaf. Communication is the key when it comes to privacy concerns. I must I must end sort of and let the other panelists to join them in this room, of course. So I thank all my speakers and my colleagues, starting from Krishna, Dev, Althaf, Paddy, and Shohini, for this wonderful session.